There aren't enough Crown courts. The state of the courts is pretty awful.
For 900 years, we've had jury trials in Britain. Keir Starmer wants to ditch them.
Serious violence has gone up and confidence in policing has fallen.
Of course, you've got gang culture as well, people acting out.
Do we not need to look at how we are going to restrict how our youngsters view the world?
Well, it's gone out the window in this case.
You can't have it both ways, surely.
I think it's a disgrace.
You've said it is incredibly serious, and people take their lives when they see themselves in what looks like a real video of themselves doing something that they never did. Before we get stuck into today's topics, over 90% of our viewers are still not subscribed to the channel. It's free and easy to do, and it's a great support to us. So please, today, subscribe and follow us. Now, let's get stuck into today's episode. Welcome to another episode of Is That Legal? With me, Paul Britton, kindly hosted by Britton and Time Solicitors. I'm joined today by Lewis Power. Mr. Power.
Morning, Paul.
You're a KC, aren't you?
I certainly am, yes.
But first of all, Lewis, how did you get into law?
Well, I took a pretty unusual pathway into law, Paul, because my initial degree I did back in Ireland, at the University of Ulster, in surveying, and I just didn't really feel that that was my vocation, so I transferred and came to England and decided to do a law degree. And from then, things worked out pretty well for me. So it was an interesting twist in terms of career path, but from an early age, being at home when we only had the 4 channels and watching such programmes as The Crown Court and Rumpole of the Bailey, that was really my inspiration. And I always wanted to be a criminal lawyer, you know, doing my stuff in front of juries, and that's what I'm doing now.
But you didn't go the solicitor route, you wanted to be a barrister. How did that come about?
Well, it was really strange because when I studied my law degree, there was about 150 people and only 3 wanted to go to the bar. I'm not sure whether in fact it's different, 36 years on, but there was only a small number at that time who wanted to go to the bar, and that's what I wanted to do.
Does the bar not require a certain level of confidence to be able to get on your feet and advocate?
There's not just a certain level of confidence, but a certain level of independence as well. Something different every day, not being office bound, and being in court as a criminal advocate virtually every day, Monday to Friday, for over 30 years.
And then moved up from being a junior barrister to Queen's Counsel at the time. You were QC and now KC. What does it mean to be a KC?
Well, it's a tremendous accolade. It's the pinnacle of one's career at the bar, because for many people, they remain, no matter how old they are, as a junior barrister. And it's effectively like a kite mark, a badge of honour once you attain Queen's Counsel, now as King's Counsel, Queen having passed. But when I got it, and you can apply many times, and I was fortunate because I got it in my first application back in 2011, and the last 15 years have just gone by in a flash.
Thank you for that, Lewis. That's really interesting. Let's get into the topics of today. The first one being the Crime and Policing Act 2026 that's just coming into effect now, and the various 5 sections, and let's have a look at what they are. So we've got corporate businesses now can face criminal liability.
Yes.
Assault against retail workers. It's easier to prosecute knife crime. Abortion decriminalisation, and also the use of AI against women and girls. I think the most important part of the new act is the use of AI against women, and not just women, all members of society, really. What do you think about that?
I think it's a really good thing. I think the law's moved into line with all modern technologies.
I mean, it's just sick, isn't it?
It is quite sick. And I know for a fact that the research has shown from those early days in school that some young girls, and in fact boys, have taken their own lives as a result of this. It's bullying, it's harassment on a different level, it's exploiting people on a different level, and it's gone to even greater levels in terms of industrial use.
I mean, I think it's just gross, but I also think the legislator's been slow to legislate.
I couldn't agree with you more. I think it's nigh time that this should have been dealt with, and I think that the new act will be welcomed. and gratefully received.
I mean, it was like the revenge porn crime when that came about, when people started.
Absolutely.
Yeah.
And in terms of the revenge porn as well, one often sees that before the courts dealing with this new offence of coercive and controlling behaviour, and it manifests itself in different ways to form part and parcel of those offences. So the courts are seeing, probably on a grand scale at the moment, a large proportion of cases which are dealing with AI-based offences, revenge porn, blackmail, coercive behaviour, which is seen also in the context of many domestic violence cases. So it's a good thing, I think, that in fact the new Policing Act has seen that in fact that there was a loophole in the law, a lacuna.
Tightened up and to protect.
It's been tightened up. And I understand that in terms of the sentencing guidelines that will come out, there's going to be greater sentences being passed, and that can only be good.
Because, I mean, as you've said, it is incredibly serious, and people take their lives when they see themselves in what looks like a real video of themselves doing something that they never did.
I think the word we're really looking for is deterrent.
Yeah.
Because unless the sentences are more stiff or more severe and indeed more harsh, then of course we're going to see it on a progressing basis. Something needs to be done.
How many places do we have in British prisons, though?
But that's another worrying factor, because of course the new legislation has been looking at trying to reduce the number of prisoners, trying to look at the models of rehabilitation to see if people can be educated, which I think is a good thing.
The rehabilitation side of it.
Well, that's a good thing, because there are new orders that are being proposed on a 3-tier system to look at rehabilitation before even licence starts, to see whether offenders and repeat recidivists can be targeted, and through education and through learning and various skills that we can get into their minds and reduce the offending overall.
Well, that segues quite nicely, Lewis, into a recent case this year where a judge spared 2 offenders detention who had been found guilty of various serious crimes against girls. Adults are obviously treated very differently to youngsters, and anyone under the age of 18 may be foregone a detention order. And I mean, this all comes from the UN Convention on how children are treated in the courts. And I think there's some wording in there that says that detention should be a last resort. And the judge in this particular case didn't give a detention order, gave other sentencing, obviously found them guilty of the crime. What do you think about that?
Well, it's an interesting question, because it's probably the most hotly talked about subject in the law, not just amongst lawyers, but in the public forum as well, because we're talking about those young lads who effectively were found guilty and were not given a prison sentence. And one can see arguments for and against, but at the end of the day, in terms of the serious nature of that offence, and I think it was rape, and in fact, since the sentence, I think it happened down in Southampton Crown Court, there's been such an outcry that in fact the Attorney General has referred it back to the Court of Appeal. But I think what, not just as a lawyer, but a member of the public, what concerns me is the impact that would have on young women for a start, young girls, not just in terms of reporting the offence, but seeing whether justice has been done.
I think a lot of the outcry comes from the judge's words where, and I paraphrase, he said something like, "We shouldn't criminalise these boys." A lot of critics of that statement have said that what the public hear is that they shouldn't be punished. But of course, they have been punished. They were found guilty. They will get criminal offences. They will have a sentence, albeit not detention. I mean, do you think the use of the word criminalised is one of the problems with that sentence?
I think that's not a bad point. I think the real danger in that particular case is the punishment in itself. But in this specific case, having read the circumstances of the case and the facts, those young boys were deemed that they knew exactly what they were doing. And because of the deterrent factor and of course the circumstances in terms of all those other young people who have been in school, who have been subjected to sexual offences, I think they were entitled, in my view, to expect that a custodial sentence would have been passed. And it remains to be seen what the Court of Appeal will do. But, and I can't prejudge that, and I wouldn't, but I expect something will be done.
Some have said that the reason the judge spared them detention was because they're still of a young age. I mean, what were they, 14, 15 when they committed
They were,
it?
yes.
They're still under 18 now. Had we put them in prison, had they been sentenced, they would come out worse, and there would be a chance that they would commit more serious crimes rather than simply look at the welfare and rehabilitation of the offenders rather than locking them up. What would you say to those critics?
Well, it reminds me of the case many, many years ago, the Jamie Bulger case.
That's right, yeah.
And that young lad being taken away from the train station and murdered.
They went to jail.
And in terms of this case, it's very, very difficult to see, in terms of the blurred lines with the gravity of the offence, how one can make a distinction.
But of those two offenders in the James Bulger case, one is in and out of prison all the time because he's constantly looking at porn online. The other is actually considered to be a much more functioning member of society and is in a relationship and is committed. But the one that's now got this propensity to continue committing crimes, does that not just play into the narrative why the judge spared them detention? Because they could end up worse.
They may end up worse, but that's not the whole picture, Paul. One has to look at probably what I would have thought is the wider point, is that young boys watching, young boys being knowledgeable of that decision, may think, well, those guys have got away with it. We can certainly get away with it. And therefore, I think the wider angle that I would have thought that is more worrying to the public is what's going to happen next.
So deterrent.
Deterrent for me
and
is
actually
the key thing.
Encouraging those that have been the victim of crimes to come forward. Because
Yes.
boys or girls, doesn't matter if you're who you are, but if you're the victim of crime, you should feel confident and safe to come forward.
Well, that's right. Can you just imagine the situation if that happened to another young boy or girl? They have seen what's happened in terms of this case. They've seen what the judge has said. They have seen that the perpetrators of the crime haven't gone to prison. And they'll think, well, should I report this? Why will I report this if I'm going to have to face the perpetrators in the street if the judge gives them light sentences?
In terms of the boys committing the offence, I mean, they were so young. How do our youngsters today become capable of such gross, heinous crimes? I mean, are they born like that? Is it in their nature?
I'm not sure if it's innate. The debate goes long and large as to whether or not people are born like that. These young boys obviously are exposed to greater social media. It opens up the wider debate on what age children should be allowed mobile phones and access to the internet, whether in fact there are any bars on the internet as to the viewing of depictions of violence or sexual scenes. And of course you've got gang culture as well. You've got people acting out, boasting, trying to succumb to peer pressure. Those are all worrying features of the youth of today.
So if it's learnt behaviour and they're learning it from their phones, looking into their phones, as a society, even as the legislator, do we not need to look at how we are going to restrict how our youngsters view the world?
Well, I think so, and I think that's happened in many countries. I think it's happened in Scandinavia. Of course, we see in Britain at the moment that phones are taken away from kids, but they have easy access to those phones once the school bell goes.
I mean, your kids are grown up, aren't they?
My kids are all grown up. I'm at that age, Paul.
What's the youngest?
22.
So if you had a 9-year-old son or daughter now, what would your view be on mobile phones?
Well, I was reading today, before I came to speak with you, about the raging debate regarding the sentences for those two teenagers. And I would be concerned as to the ramifications and impact of that case. It would be highly worrying for me, and I appreciate the concerns of the parents and all these pressure groups who are worried about the escalation in not just violent crime but in sexual crimes, And I think that the government need to do something serious about it and take a long, hard look at it.
But would you give your 9-year-old a smartphone?
No, I wouldn't.
What would you do?
I think, and it's only my personal view, possibly teenage years, albeit, I wouldn't be very popular because kids all want them now. You see children as young as 4 and 5 with iPads.
But the kids wanting them, I mean, how dangerous is it as a parent now to acquiesce for a quiet life to then give that to your child?
Well, it's all about an easy life, isn't it? It's like the old adage, when someone got a new pair of trainers with a designer brand and one of the kids wanted them.
But this is a bit different. I mean, given a pair of trainers, it's very different to giving someone a piece of technology, a phone, where they can peer into a social media feed, which is going to feed them a certain narrative. And the longer they look at it, the more it's going to feed it to them. So if they start looking at violence, they get caught on it, it's going to pump more violence to them.
Well, I think that goes back to the argument about isolation and being different and wanting to be inclusive as a child. In my experience, in terms of children and isolation, in terms of peer pressure and wanting to be accepted, then if everyone else has got a phone, then there is a danger that that specific child would want to be included. So it's difficult. It's a difficult debate. But I think that perhaps the answer is that the actual internet providers, people further up the chain, that's where it needs to start. That's where changes need to start.
The final point on this is one of the reasons these boys weren't given a detention order is because they're young and they're considered not to understand the full ramification of their acts, that they can't think properly like an adult. They're very impressionable. Why is it then that we want to reduce the voting age to 16, but we don't treat 16-year-olds as adults when it comes to criminal sentencing?
Well, I think there's a big difference between individuals and youths of that age who can form criminal intent as opposed to 16-year-olds who want that degree of independence.
But they may vote for a particular political persuasion, but they don't understand. The argument for not sentencing them like adults is that they don't think like an adult. Their brains aren't fully developed yet. So why allow them to vote when they don't understand what they're doing?
Well,
you can't have it both ways, surely.
You can't have it both ways. In fact, I remember research recently that said that the adult brain actually doesn't reach formation until you're about 21 or 22. And yet the voting age is 18 and we want to bring it down to 16.
When on that logic, we should be putting it up to 21 or 22.
But you look at the other side of the coin, Paul, because you're talking about adult women and girls who can be married, is it 16 years of age? But coming back to your question about how do you make that and distinguish it from youngsters who are 13 or 14 who are engaged in criminal acts and what should happen to them, I think that's a completely different argument, because it's being at that specific age where you know the difference between right and wrong. And it's the difference between right and wrong that really determines whether or not you should be culpable for a criminal act. And the scale of that particular case leads me to the conclusion, if in fact I were the sentencing judge, whilst of course one has to protect the youth and what one has to think of the potential ramifications in terms of whether that could have a deeper impact on criminalising them later in life, one has to look at the specific circumstances of a case. And in this particular example, shading it, I think he got it wrong.
So do you think judges have too much discretion when it comes to cases like this? Should there be more of a rigid sentencing guidelines, like a starting point? If it involves rape, sexual assault, the starting point should be at least.
Well, that's why for most offences before the courts now, you have got sentencing guidelines. And of course, judges, circuit judges and recorders have to rigidly apply those. They're not tramlines, they're guidelines. But it gives them a certain degree of confidence in terms of what the starting point should be for a particular sentence.
And what the public will expect.
What the public will expect and the range of sentencing. And
but for children, doesn't that all go out the window?
Well, it's gone out the window in this case because a custodial sentence was not granted.
No.
So it has gone out the window.
So maybe we should look at those the guidelines for judges sentencing youths.
I think that's the way forward.
Before we continue this episode, a word from our sponsor. This episode of Is That Legal is sponsored by Oliver Lorenz Studios, your on-demand design team for B2B service providers. They're your dedicated design partner, delivering consistent, high-quality creative without the overhead of hiring in-house. Think bold branding, polished presentations, and visual content that actually moves the needle. Check them out at oliverlorenzstudio.com. Design support just when you need it. One that's always gets my goat is the legal aid barristers protesting. And I'll tell you why it does. I just think these things can be achieved through dialogue and campaigning, but wearing your wig in your gowns outside of court, I think that was a bit too much.
I think I'm going to stand my corner in this one, Paul.
Did you wear your gown and wig outside of court?
I didn't actually go on one of the protests, but only because I was involved in Crown Court cases at the actual time. And I
So
know
would
that
you have, though?
I felt very strongly about it because when anyone asks a barrister, for a story, most people go to a criminal barrister because people want to hear about stories. They want to hear about real life. And of course, for many years, that experience, that skill, we feel hasn't been properly reflected in the fees, especially the junior barristers who for years were performing very high-skilled tasks, hard work long into the evening without proper remuneration. So, coming to your question in terms of barristers going out, yes, I do feel that was right, because for many years those fees had been stagnant. They hadn't been a change in about 20-odd years. And whether, in fact, I'm saying this as a criminal barrister who has benefited from the changes, then I think the time was right, and I think they were right to protest.
And thinking about the criminal justice system as a whole, what state is it in at the moment?
Well, there's a tremendous backlog of cases. There aren't enough Crown courts. The state of the courts is pretty awful. There just aren't simply enough courts. And of course, there were those Nightingale courts as a result of COVID, but many of them are now defunct. And of course, we've seen this massive backlog. There's the great debate raging at the moment as to whether we get rid of the jury, which I'm totally against.
Well, let's talk about that. So we've had juries for, back to Magna Carta, right? So the right to be judged by your peers. What do you think about the removal of that protection from members of the public?
I think it's a disgrace, personally. I think the British system of being tried by a judge and jury, a number of your peers, is the greatest system in the world. It's been copied around the world in many jurisdictions. And in fact, it's the envy of the world, the British legal system. And I think, only because I've been doing it for 36 years, that it's the kite mark of fairness, it's the kite mark of a defendant receiving a fair trial, and I just think it's the way forward. Could
you have 12 members of the public, just like you, if you're committed, if you're accused of an offence, that determine your guilt, rather than an institutionalised judge, is what some would say?
That is the salient point, because you're going to be getting a fair trial amongst your peers. It's a bit of a lottery, I suppose, whether you get a judge who's known to be a bit stiff in sentence or a bit light in sentence. But at least, no matter which judge you get at the end of the day, the judges of the actual facts, the people who return that verdict, are 12 independent people, totally unconnected to you, who have assessed your case and the facts, of course, taking all the legal directions from the judge himself. And I think it's the fairest method.
I mean, doesn't it go to the crux of the separation of powers, the legislature, the executive, the judiciary, and it stops corruption and tyranny by having 12 members of the public that aren't connected?
I think it goes to what they're calling institutional bias. I think the fact that you could have a jury determine whether you're innocent or guilty is probably the fairest way of dealing with it. And I believe that it prevents injustice, because the juries seldom get it wrong. Very seldom.
So it's outrageous that the current government is trying to take moves to remove that protection from members of the public.
I only think that, Paul, because I have been a jury advocate for over 3 decades. And in those 3 decades, in my professional opinion, and in fact in my personal opinion, juries seldom have got it wrong.
So I mean that's juries, and well, let's hope that they stay. You've now been a barrister for how many years?
36 years, Paul.
You must come across some crazy clients and some interesting stories.
Well, one of the funniest ones, Paul, I'll take you back about 36 years, and when I started out, and obviously I treaded the boards and the magistrates, and then I got my big break at a Crown Court trial. It was one of the first ones, and it was one of Chambers' most prominent solicitors, and he said, "I trust you with this job for this client." And I think it was an ABH and
Actual
case,
bodily harm for anyone that
actual
doesn't get
bodily
that, yeah.
harm, where the client was in custody, and he told the client, "This is Mr. Parr's first trial." And I remember he said, "We expect great things from you." And he wrote the client a letter, which he showed me. And the letter went something along the following lines. "Dear Mr. Wilkins, I'm delighted to tell you that for your trial at the Isleworth Crown Court, we have got a new robust young barrister, Mr. Lewis Parr, who will be representing your interests. Mr. Parr has been provided with the full brief and instructions. He's been told your defence. I know for a fact that Mr. Parr will defend you to the umpteenth quarter. He is diligent, he is hard-working, he is earnest, and I know he will do a fantastic, brilliant job. In the meantime, please proceed with your escape plan."
The letter actually said this.
I only found out afterwards,
Oh my
Paul, that
God.
he was winding me up.
Oh, okay, fine.
But that was before my first ever trial.
Yeah. How did the trial go?
I won it. I won my first trial. I remember it vividly. And of course, it's those things in life.
Yeah.
Getting a win. My old pupil master used to teach me 3 things.
Yeah.
His 3 basic rules were, first of all, it's not about the taking part, it's about the winning. The second one was, at all stages, never trust a client. And his third rule was, he said, you don't have to score a run off every ball. And that was really good advice, because sometimes we're in your court, you think winning is everything, you go on the attack, but sometimes you have to sit back, let it happen, defend your position.
More measured.
Be more measured.
Like boxing, take the hit sometimes. And
sometimes take the hit,
when
go
it
on the
turns,
ropes sometimes. Yeah. And, I always say to young advocates, it's not about one gear, it's about many gears, about many facets. And it's about reading the jury, and it's about reading the situation. And that's great advocacy. It's coping with what's in front of you, dealing with it, and skillfully taking the case head on and thinking in your feet.
Yeah, it's true. I mean, there's some law firms that I come up against too in London, and they just have one gear, just pure aggression all the time, and it never really works out well for them, because they just are totally incapable of changing gear as the case moves on.
Each case is always different, and each case you just have to...
Just like every car.
Probably more cars than I have, Paul, but that's for another day, isn't it?
Well, thank you, Lewis, for joining us on Is That Legal? That's all we have time for today, Lewis. Thank you for joining us with me, Paul Britton, and...
Lewis Parr, KC. It's been an absolute pleasure, Paul.